To get things started, I'm going to turn it over to Gabriel Pacyniak, who is the Institute Associate at the Georgetown Climate Center. He's going to come up and drill down a little bit on the issues before the DC Circuit, background information, and after he does that, he's going to turn it over to John Cruden and the first panel. So, Gabe, come on up, please. Thank you.
I'd like to set the stage a bit for the panelists that are going to come after me and talk about the regulatory actions that are at issue in these 4 cases and the procedural posture of the case. So there, in an oral argument, there were 4 cases that were heard in front of the court. They relate to a variety of EPA actions. The first set of consolidated cases dealt with the endangerment finding, where the EPA found that greenhouse gas pollution endangers public health and welfare, and that pollution and that emissions from motor vehicles causes or contributes to that pollution. In the second set of cases, consolidated cases, deals with the light-duty vehicle rule, where EPA regulated greenhouse gas emissions and NHTSA regulated fuel economy. The petitioners in that case were not so much challenging the substance of the regulations with regards to motor vehicle manufacturing, but rather its triggering effect for regulations of stationary sources under the Prevention of Significant Deterioration Program, or the PSD program. In the third set of cases that was heard, the historical interpretation docket, the petitioners challenged EPA's historical interpretation of the applicability of the PSD program, arguing that at least in the case of greenhouse gas emissions, the EPA's interpretation was impermissibly broad. And in the fourth case, the petitioners challenged the tailoring and timing rule. These 2 rules relate to the EPA's application of PSD and Title V permitting requirements to stationary sources and greenhouse gas emissions from those sources. And in specific, the EPA in the timing rule decided when greenhouse gases would be subject to regulation, therefore triggering PSD, and and to what sources would be subject to PSD requirements, specifically what level of threshold would be subject. And EPA decided to phase in PSD regulation for greenhouse gas permitting, raising the numeric threshold to only subject very large sources, either those that were already being subject to PSD requirements or those emitting over 75,000 to 100,000 tons per year. This was significantly greater than the threshold in the statute, which required regulation for major sources emitting over 100 or 250 tons per year. The EPA justified this action by saying that the statutory thresholds would have subjected tens of thousands of new sources to regulations, creating an unworkable burden, and relied on the doctrines of administrative necessity and absurd results to justify their rule. So I'm going to start with a little bit of background, which I have no doubt is familiar to all of you. These 4 administrative actions respond to a petition to regulate greenhouse gases under Title II of the Clean Air Act and the eventual Supreme Court decision in Massachusetts v. EPA. That petition was first filed in October 1999, and the petitioners relied on the language in Section 202A of the Clean Air Act, which requires the EPA administrator, says the EPA administrator shall prescribe regulations for, quote, any air pollutant which in his or her judgment causes or contributes to air pollution reasonably anticipated to endanger public health and welfare. The agency denied that petition in 2003 and provided 2 reasons for that denial. First, that the Clean Air Act did not authorize the EPA to issue mandatory regulations to address greenhouse gases. And second, that even if it did have that authority, it would be unwise to use the authority at that time. In 2005, the petitioners appealed and the DC Circuit upheld the EPA's petition denial. The 3 judges on the panel each wrote their own opinion, and notably, 2 of those judges were the same judges that heard the cases the previous 2 days, Judge Santel and Judge Tatel, and I'll discuss their opinions a little bit more a little later. In 2007, that case was accepted on cert to the Supreme Court, and the Supreme Court reversed the lower court's decision, remanding the petition back to the agency and holding on the merits that EPA did have the statutory authority to regulate greenhouse gases under the Act, because of the capacious definition of air pollutant in the Clean Air Act, and that EPA could avoid taking further action only if it determined that either greenhouse gases do not cause or do not contribute to climate change, or if it provides some reasonable explanation as to why it cannot or will not exercise its discretion to determine whether they do. So two of the actions at issue today respond directly to this petition and to the Mass v. EPA ruling. The first one is the endangerment finding, the final rule of which was issued in December of 2009. The EPA made two distinct findings in the endangerment finding. First, that the current and projected concentrations of carbon dioxide, methane, and 4 other gases threaten the public health and welfare. And second, that emissions of these well-mixed gases from new motor vehicles and new motor vehicle engines contribute to the GHG pollution that creates that endangerment. It should be noted that 2 of those gases, perfluorocarbons and sulfur hexafluoride, are not emitted by motor vehicles, and I'm sure the panelists will discuss that today as that came up repeatedly in oral argument. It should be noted that there were at least 10 petitions for reconsideration and 2 related administrative stay requests. Many of these relied on new emails that were released, the so-called ClimateGate emails. All of those petitions were denied by EPA in July of 2010. In these cases, consolidated in docket number 9/1322, petitioners make, among other claims, allege that EPA uses an impermissible interpretation of Section 202A because in their endangerment finding they did not consider the assessment of regulatory impacts. They also argue that the finding is not reasonable under the arbitrary and capricious standard, and that EPA impermissibly denied the petitions for reconsideration. The second rule relating directly to that petition in Mass v. EPA is the light-duty vehicle rule, or the so-called tailpipe rule. I'll remind you that in Section 202A it says that where the administrator finds endangerment and that pollutant contributes, or that emissions from motor vehicles contribute to that air pollution, the administrator, quote, shall prescribe vehicle standards. Separately, the National Highway Transportation Safety Administration, or NHTSA, is required to set corporate average fuel economy standards for cars and trucks under the Energy Policy and Conservation Act. EPA and NHTSA issued a joint rule in May 2010, which regulated both greenhouse gas emissions under the Clean Air Act and fuel economy standards under EPA. This rule applies to light-duty passenger vehicles for model years 2012 through 2016, and the rules took effect for the model year 2012 fleet on January 2nd, 2011, a date that becomes important because of its triggering effect for regulation of stationary sources under the PSD program. It should be noted that the automobile manufacturers supported this rule publicly and in fact have filed an amicus brief in support of the respondent EPA in this case. The petitioners in this consolidated docket, number 10-1092, focus not on the rule's substantive regulations with regard to motor vehicles, but rather on the ramifications for stationary source regulation under the PSD program. One of their central claims is that EPA should have considered the cost of PSD regulations triggered by the light-duty vehicle rule, citing Section 202A2 of the Clean Air Act, which states that EPA must give appropriate consideration to the cost of compliance. These 2 actions, the endangerment finding and the light-duty vehicle rule, arguably triggered other regulatory obligations under the Clean Air Act. Specifically, the Prevention of Significant Deterioration Program and the General Operating Permits provisions under Title V. The PSD program, located in Part C of Title I, is a pre-construction permitting program for stationary sources. It applies to major emitting facilities and states that no major emitting facility may be constructed unless a permit has been issued in any area to which this part applies. And in EPA's interpretation, this in fact would set a construction moratorium if no permit was applied, if no permit was issued and PSD applies. Importantly, the Act sets statutory thresholds for affected sources. A major emitting facility is defined in Section 165A1 as any stationary source that emits or has the potential to emit more than 100 or 250 tons per year, depending on the category of the source. And moreover, that threshold applies to, quote, any air pollutant. Sources subject to the PSD program must apply best available control technology, or BACT, and that is determined on a case-by-case basis, usually by state permitting programs. Importantly, again, in the statute, BACT is to apply for, quote, each pollutant subject to regulation under this chapter. And so in EPA's historic interpretation of the applicability of this section, EPA has held that the PSD provisions apply to, quote, any pollutant subject to regulation under the Act, not just to NAAQS pollutants or criteria pollutants, which are one of the main focuses of the PSD provisions. This interpretation of the EPA's was adopted in 1978, shortly after the PSD section was included in the Clean Air Act and the 1977 amendments, and has been reaffirmed in rulemakings in 1980 and 2002. The second part of EPA's interpretation is that PSD applies to facilities in areas classified as in attainment or unclassifiable for any pollutant, not just for NAAQS, which means that in the case of greenhouse gases, since all areas are unclassifiable for purposes of greenhouse gases, that every major emitting facility would be subject to PSD. Again, that interpretation also goes back to 1980. So the other program that it's implicated is the Title V program. The Title V program is an operating permit program. It doesn't have any substantive pollution control requirements, but rather is meant to ensure that all applications, all relevant provisions of the Clean Air Act are applied for any given source. Like the PSD program, the Title V program has a statutory threshold and applies to major emitting facilities. In that case, the threshold is 100 tons per year, again, of any air pollutant. And so at issue here is whether or not the EPA's historical interpretation, or rather under EPA's historical interpretation, the PSD and Title V programs would be triggered as soon as greenhouse gases became subject to regulation. And when that happened is the focus of the timing rule, or rather a memo that EPA released in April of 2010, which reaffirmed its previous interpretation that a pollutant becomes subject to regulation once that pollutant is subject to active controls on emissions. EPA in this memo determined that that date would be January 2nd, 2011, the date that the light-duty vehicle rule would apply to the model year 2012 fleet. The second action that EPA took, and in many ways the central action that concerns all of this litigation, is the tailoring rule. Again, here EPA sought to address the very low statutory thresholds of 100 and 250 tons per year, which when applied to greenhouse gas emissions would subject, in EPA's determination, over 80,000 new sources to PSD requirements, whereas currently for criteria pollutants, only several hundred sources are subject to PSD. In the tailoring rule, EPA proposed to phase in PSD and Title V regulations for greenhouse gas emissions, beginning only with sources that are already subject to those programs for criteria pollutants and that emit over a much higher threshold, 75,000 tons per year. And in the second phase of that program, only very large sources, new sources emitting over 100,000 tons per year, or major modifications that would increase emissions over 75,000 tons per year. So as you can see, that is a dramatic increase in the threshold affected from the statutory threshold of 100 or 250 tons per year. EPA justified this action on the grounds that the very low thresholds in the statute, which would have imposed undue costs on permitting agencies, including the states that carry out most permitting, and because it would overwhelm and it would impose undue costs on small sources. To justify this conclusion, it drew on the judicial doctrines of administrative necessity, one step at a time, and absurd results, which will be discussed in detail, I'm sure, in the next panel. The petitioner, so in the first case relating to these two actions, it's called the historic regulation docket, and petitioners are challenging again the historic interpretation of EPA's historic interpretation of the applicability of the PSD program. Here, petitioners claim that at least with regards to greenhouse gas emissions, EPA's broader interpretation of PSD application is impermissible. and in part because it would lead to absurd results or administrative necessity, these doctrines of last resort. It should be noted that in these claims, there are some substantial issues, some substantial jurisdictional or ripeness issues that arise, in part because EPA's interpretation is over 30 years old and has been sustained in previous litigation. Petitioners here argue, however, that their claims are timely because they arise out of EPA's current GHG regulations, and moreover, because EPA's GHG regulations would expand the coverage to tens of thousands of new sources in the future and would therefore ripen thousands of new claims. In the second case, the regulation at issue is the tailoring and timing rule. And in that docket, number 1073, petitioners claim that EPA impermissibly, the tailoring rule is contrary to the clear language of the statute, again referring to the difference between those statutory thresholds and the phased-in thresholds used by EPA for very large sources. They argue that EPA rejected interpretations of PSD applicability that would have avoided the use, again, of these doctrines of last resort, administrative necessity, and absurd results, and argue also, in part, that EPA actions violate the delegation of powers doctrine by usurping legislative authority. It should be noted that in this case, there are some significant standing issues, in part because EPA's rationale for the tailoring rule is that it would reduce the number of sources that are subject to regulation, and because the petitioners claim that their harm is this increased regulatory burden. And so the question is, how are the petitioners harmed by a rule that actually seeks to reduce the regulatory burden? So now I'd like to talk just a little bit about, to provide some information on the procedural background to give context to the arguments that were heard the previous 2 days. First, it should be noted there have been several motions, 4 of them, to stay the greenhouse gas rules, or at least to stay their triggering effect with regards to regulation of stationary sources under the PSD program. The DC Circuit denied all 4 of those motions. As I mentioned before, the rules are already in effect. Light-duty vehicle rule went into effect January 2nd, 2011, and applies to model year 2012 vehicles and 2013 vehicles now that are already out in the market. And the PSD rule was triggered at the same time and now is already in phase 2 of the PSD rule, which again applies to all large sources, new sources emitting over 100,000 tons, and existing sources undergoing major modifications, increasing emissions over 75,000 tons. And in fact, EPA has permitted or is in the process of permitting a number of sources under that tailoring rule provision. It should also be noted that there was a motion to combine all of the related cases, more than just these 4 cases, into a hearing in front of one panel. But the court denied that motion, but did decide to hear these 4 cases at the same time in front of this panel. The panel included, the 3-judge panel included Chief Judge Sentel, who was nominated to the DC Circuit in October 1987 by President Ronald Reagan. He became Chief Judge in February 11, 2008. He was a graduate of University of North Carolina Law School. He served as an assistant U.S. attorney, as a judge in U.S. District Court in the Western District of North Carolina, and in private practice. Judge David S. Tatel was nominated to the U.S. Circuit by President Bill Clinton on June 20th, 1994. He had previously served as an instructor at the University of Michigan Law School and in private practice, and also as a director of the Chicago and National Lawyers Committee for Civil Rights Under Law, and as a director of the Office of Civil Rights in the U.S. Department of Health, Education, and Welfare. Finally, Judge Judith Ann Wilson-Rogers was nominated to the D.C. Circuit by President Bill Clinton on November 17, 1993. She served as an assistant United States District Attorney in the District of Columbia, at the Justice Department and the Deputy Attorney General's Office in the Criminal Division, and as Corporation Counsel for the District of Columbia. As mentioned previously, Judges Sentel and Tatel were on the 3-panel circuit that heard, the 3-judge panel that heard Mass v. EPA at the DC Circuit level. There, Judge Sentel at that time would have found that petitioners did not have standing because plaintiffs lacked a particularized injury. But in order to provide the 3-judge panel with a majority opinion, he concurred in judgment with Judge Randolph, who agreed with EPA that it could deny the petition on its policy and its discretion not to regulate, citing policy grounds. Judge Tatel's dissent, on the other hand, in large part previewed the eventual majority opinion at the Supreme Court. Judge Tatel would have found standing for at least the state petitioners and would have found that the Clean Air Act clearly gives EPA authority to regulate greenhouse gases. He also would have denied EPA's argument that it can withhold regulation for policy reasons that do not specifically relate to Section 202 statutory standard. And finally, I wanted to mention the order of oral argument that the court ordered, which is the order in which the panelists will present. On day one, the court ordered the endangerment finding to come first for 1 hour and 30 minutes, and then the tailpipe rule for 40 minutes total. And on day two, combined oral argument of both the historic regulations and the timing and tailoring rule for 2 hours and 30 minutes of argument. Importantly, in the second day of argument, the court instructed parties to address the jurisdictional issues specific to each case first, meaning that with regards to the historic regulations rule, to address the timeliness of the challenge, seeing as it was coming 30 years after the interpretation had originally been made and sustained. And with regards to the timing and tailoring rules, to address the standing to the challenge, seeing as the parties alleged an injury of excessive regulatory burden, where the EPA claimed that the rule was actually reducing the regulatory burden. So thank you very much, and with that, I'll pass it off to John Cruden.
What Gabe didn't tell you, he is a 2-month-old. Any of you who are young parents understand that he probably had no sleep last night. Let's have a round of applause for Gabe as a... Gabe, that was an excellent summary. It sets the stage perfectly for the panel we're about to talk about, a panel of experts. Each and every one of them were not only in the courtroom for both days, but they also submitted briefs to the court. And that's what we're going to do. We're going to try to take you into the courthouse right now and give you a picture of what occurred during oral argument by true experts in the area. But visualize this. I mean, come on, it was raining on Tuesday. Visualize long lines in front of the courthouse, people standing out there starting at 6:30 in the morning so that they could then fill the ceremonial courtroom of the Court of Appeals of the District of Columbia. And then you walk in, and the first half of the court are all of the parties. You know, there are high-ranking justice officials and state officials and public interest groups and all of the different industry people represented there. There are law classes, Harvard law classes, and other people who have been studying these things for months, all sitting there watching, hanging on every word of the court. And for the court, it's back to the future. Here we have Massachusetts versus EPA, two of the judges who decided it there, and even Judge Rogers had agreed with Tatel in the en banc petition that came later in Massachusetts versus EPA. And so we have those key individuals, and all of a sudden now the Supreme Court decision is the 11th commandment. And every word, every breath of that contested decision is now spit back to everybody arguing, and they actually have to justify themselves not only based on statutory language, but now how it was interpreted by the Supreme Court. And the first day was like that. The first day was all Massachusetts versus EPA, all statute, endangerment flowing from that Supreme Court decision, the car rule, the very first of the statutes actually applying the endangerment finding and thereby regulating pollutants. Tatel, Centel are in sync. They are filling in each other's questions. They are forcing other arguers to answer each other's questions. There are a lot of laugh lines, but remember, if you're arguing before a judge, you have to laugh if a judge gives you a joke. There. The second day, though, is more like the D.C. Circuit that we have all come to love. It is an administrative law feast, and at one stage, Tatel turns to the students in the audience and says, It doesn't get any better than this, administrative law. You have standing issues, you have rightness issues, you're doing canons of interpretation, your timing of challenges. There are hypos and counter-hypos. There are strategic rebuttals. But what we had by all parties, we had wonderful advocacy, and we had a very, very prepared and hot bench. And those are the kind of things that lawyers live for. So, okay, so the panelists that we have today, I told you before, they all participated, they all wrote briefs, they're all experts in the area, and where we are really lucky to have them, each of them will be speaking in their individual capacity. They have clients, they have states, they have other organizations they are representing, but they're here speaking individually to each and every one of you. And they will all speak to at least one rule and then give observations on the rest of the argument as they think is appropriate. And I'm going to introduce them in the order that they will speak. To my immediate right, your left, speaking first is Tracy Triplett, who's an Assistant Attorney General in the Environment Protection Division of the Massachusetts Attorney General's office, and she has been since 2008. She's one of the leading litigators on Massachusetts environmental laws, and she, in fact, wrote portions and was lead on many of the briefs for Massachusetts. Next would be Tim Webster. Tim is a partner at Sidley in Austin. He is actually quite well known in the D.C. Area in particular as an extraordinary advocate. Before then, he was at Department of Justice's Environmental Enforcement Section, and he is counsel for interveners. Next to Tim on his right is Meleah Geertsma, who is an attorney in NRDC's Climate and Clean Air Act program, where she focuses on reducing greenhouse gases through the Clean Air Act. She's lead counsel for NRDC on the briefs submitted by the environmental groups and states supporting EPA's rulemaking. And then, as I explained to Bill, he is our cleanup hitter. He's a partner in Jackson Walker's Austin office in Texas, but he hasn't been there too long. Shortly before he arrived, he was senior counsel to the Attorney General of Texas, and he headed Texas litigation opposing EPA's greenhouse gas regulations and defending Texas's air permitting program. It's a great group. They'll all speak, and then we'll have time for questions at the end. But Tracy, let's start with you. What happened to the endangerment finding in court?
The argument, at least especially I think the second day. Before I start, I just want to give the standard government employee disclaimer, and that is whatever I give today, they're my own and not that of the Massachusetts Attorney General's office or the Commonwealth of Massachusetts. Having said that, I think John is correct. Most of the discussion in the endangerment finding case really centered around the meaning of the particular statutory provision at issue here, and also what Mass v. EPA said about that language. And I think the key terms that came out in the argument are sort of what's the meaning and what's the scope of the administrator's judgment. Similarly, what's the scope of may reasonably be anticipated to endanger, and how much room is there in that language for a number of different factors that the petitioners had been advocating EPA should have considered. To a lesser extent, there was some discussion about how much discretion does EPA have in interpreting and applying those terms. The other issue that was alluded to that was really of interest to the court, particularly Judge Santel, was whether or not EPA had properly defined the air pollutant or the air pollution at issue here. And so those are really the two main things that I want to comment on. I was going over my notes last night. It was hard not to be distracted by what happened on the second day, to go back to the first day. But at any rate, on the air pollutant issue, as Gabriel said, that EPA defined the air pollutant and air pollution at issue here to be 6 globally well-mixed greenhouse gases, and 2 of those are not gases, and there's no dispute, that are emitted by motor vehicles. During the argument, counsel for EPA explained the basis for that the definition of air pollutant allows for consideration of a combination of air pollutant agents, and in this case, there were shared attributes between these 6 different gases that really were relevant to the greenhouse gas pollution at issue, that made sense to consider them together, and also gave some examples of other situations like VOCs or particulate matter where EPA has taken a similar approach. Judge Santel pretty early on indicated he had some concerns about that approach. I think he used the word disturbed a couple times, and he really latched onto that issue. And what was of concern to him that you could see from his questioning was, we're regulating a particular source under Section 202, and that's motor vehicles, and they don't actually emit two of the gases that are defined as the air pollution at issue. And I thought counsel for EPA did an excellent job trying to explain the basis for that decision, the scientific basis, the agency discretion, the reasons in the statute, but he was not convinced. He didn't seem to me to be open to that, I suppose, just because he also continued the same line of questions into the second day. It was also an issue to a lesser extent in the tailoring case. He made some distinctions between VOCs and particulate matter. He seemed concerned that particulate matter is grouped based on size rather than composition. I didn't think that he would be convinced during the argument as a result of that, and certainly sleeping on it overnight didn't seem to have changed his mind. And he actually also asked a few times, well, what if the court were to uphold the endangerment finding based on the 4 gases that are emitted by motor vehicles and exclude these 2 that aren't. And I believe there's a specific place in the endangerment finding, and Department of Justice attorney pointed this out, where EPA made a specific determination that if it were just the 4 gases that are emitted, it would still find endangerment. So that was put out there. Wasn't a lot more questioning put forth on that issue. The other thing that came up in this context was the standing of the petitioners to even be raising this issue. And actually Judge Rogers, who didn't, particularly in the endangerment case, didn't ask a lot of questions. She actually raised this first, and then it wasn't followed up on at that point, but then Judge Santel actually pursued the standing question more. So the issue there is, how is anyone but an entity who's regulated under the vehicle rule in Section 208(2) injured by inclusion of these 2 pollutants that aren't emitted by vehicles? The counsel for petitioner explained that there are some stationary sources like utilities that would be emitting the sulfur hexafluoride from transformers. And that really led to some questioning from both Judge Santel and Judge Rogers. Well, is there a petitioner who is injured just because of one of these 2 pollutants? Is there a petitioner for which the sulfur hexafluoride is the but-for cause of regulation, even at the stationary source point? And there, at least not on the record, there doesn't appear to be such a petitioner. And in fact, Judge Rogers noted that I think she had been quite curious about this issue, that she had been looking in the reply brief for that type of response and hadn't actually seen it. So I said that the discussion actually continued into the next day a bit. I don't recall the questioning or discussion being terribly different from the first day, but I'm sure perhaps one of the other panelists will speak to that a bit. It seemed like the same issues coming up and not really getting probably resolved. The other sort of general issue I think that came up a lot in the endangerment case was the extent to which EPA could or is required to consider what you might call sort of non-science factors in making the endangerment determination. I would say my impression was that overall the court wasn't particularly receptive to the argument about things that the court would consider non-science factors. From how I recall, it was almost in like the first minute on the first day that Judge Tatel just got out there and said he viewed Massachusetts v. EPA is really requiring a science-based analysis related only to endangerment. And it was not even really part of questioning. He just put it right out there. He's later on cited some language from the opinion involving the need for a scientific judgment that portion of the opinion involved the Supreme Court discussing or deciding that it wasn't appropriate for certain policy factors that EPA had invoked for denying the petition, and was indicating that those factors they don't amount to a reasoned justification to decline to form a scientific judgment. So this was clearly important to him. I think that the petitioner's argument here is that, well, Mass v. EPA doesn't actually require, that you consider solely, scientific factors. You should look at the statute as a whole, and there's a portion of the DC Circuit's decision in the Ethel case that talks about the term endangerment being informed by the rest of the statute. I think, questioning throughout the argument about these issues, Tatel was always coming back to, what he thought scientific judgment meant, and he was trying to understand. At one point, he's like, tell me how I would write an opinion that would account for the discussion of scientific judgment in Mass v. EPA, but also allow me to consider your various factors. And my recollection is Sentel had some similar questions, but Judge Tatel was really leading that line of questioning. And so when you go through the specific sort of, this may be my bias calling them non-science factors, but be that what it may. One issue that petitioners have raised was, well, EPA should have quantified the endangerment risk that would actually be reduced by the vehicle standards when that part of when the standards was set, in order to determine whether those standards are actually effective in addressing the endangerment. And I think both Judge Sentel and Judge Tatel question, well, how is that not precluded by Mass v. EPA? The language there is really about endangerment. That's the determination at issue. There was, at one point, I think it was Judge Tatel said, where is there room for adding a clause about rationally reducing endangerment? The same type of questioning came up with regard to the absurdity argument that petitioners have, that the idea that the absurdity that will result for stationary sources down the line is something that should have informed EPA's endangerment finding. I think all three judges felt like that was an appropriate consideration in this particular challenge or in this finding. Sentel at one point said, I think that's really for the timing and tailoring case, which would be the next day. And Judge Tatel was sort of asking, well, where's the authority for EPA to fix that absurdity in the endangerment finding as opposed to later on? And Judge Rogers, who I said didn't do a lot of questioning that day, she at one point said, I think, isn't the argument here really that EPA should have done the endangerment finding and then stopped there and maybe not proceeded to the vehicle rule because of the absurdity? Isn't that really more what you're saying? And I think, also there was one point where Judge Sentel raised some issues. Well, isn't this an effort to take greenhouse gases, out of the definition, the general definition for air pollutant in the statute? Is this about relitigating Mass v. EPA, which I'm not sure how anxious he would be to do. And I think the final factor that came up, but not with as much discussion, it was really a focus by Tatel, is this issue of adaptation and mitigation, whether EPA should have considered, would society be able to adapt or mitigate in the future some of the impacts from climate change? And is that something then that EPA should have considered in assessing those harms in its endangerment finding? Judge Tatel actually raised this early on, almost to flag it, and it was a little bit later that he was able to discuss it a bit, and he described it as something that had been intriguing, one of the factors the petitioners mentioned that had been intriguing to him. And he really wanted to understand how, as a practical matter, should EPA consider this type of factor? How should it evaluate whether migration away from coastal areas is something that would be likely to occur in the future, and whether or not it would be a sufficient response? And there was some discussion in that point about looking at historic analogs, how you would actually do this. And at that point, Sentel thought, well, how is EPA's expertise about looking at demographics and migration and things of that nature? And I thought there was sort of an interesting response that, well, if EPA can predict the weather, I'm sure they can handle this. And then finally, I'll say that after Judge Tatel raised this, he then put out a hypothetical that that left me wondering, maybe he's not really that interested in this. And he put out this hypothetical: what if you're dealing with a carcinogenic air pollutant? Should EPA be assuming that someday we'll have a cure for cancer, and should it be taking that into account in thinking about the impacts? That's not an easy hypothetical to deal with. I think that sort of ended up in some discussion whether there's a difference in what you consider for a public health impact versus a public welfare impact. Public health impact, perhaps, I think the argument petitioners are making is maybe a more, this ties into their inhalational direct impact sort of argument. I didn't get the sense from just observing the justices, and this was at the very end of a line of questioning where we're going to switch to yet another attorney, because there were a lot of attorneys. I didn't get the sense that they had really latched onto that argument, but I did note that when we switched to the next attorney, which was an attorney from the Department of Justice, Judge Tatel did pose the question, is there something about this? Is public health more clearly a science issue, and is welfare a broader concept? But there wasn't really a continuation of that discussion.
Tracy, thank you very much. If the endangerment finding answers the questions and direction of the Supreme Court in Massachusetts versus EPA, nothing happens from it. Nothing happens until it's applied. And the first time it's applied is in the motor vehicle rule. Tim, what happened? What happened in motor vehicle?
Well, we refer to it as the tailpipe rule, although I've heard lots of people call it lots of other things as well. The tailpipe rule is really kind of the odd man out here in terms of the rules that were under review before the court, and I mean that in the following sense. First off, it was really two rules, as Gabe mentioned at the beginning, an EPA rule and NHTSA rule, the Corporate Average Fuel Economy Standards. Second, and in fact, importantly, the NHTSA part of the rule was not really challenged by any petitioner. There were a couple who named NHTSA in their petition for review, but when you look at the briefs, there was no one who was actually challenging that part of the rulemaking. And in fact, there is a great deal of similarity in the ultimate consequences of the two rules as they relate to the combustion byproducts, the greenhouse gases that come from combustion. The substantive difference between the EPA rule and the NHTSA rule really came in the form of the fact that the EPA rule covers air conditioning systems, whereas the NHTSA rule does not. Secondly, as I said, no one actually contested the NHTSA rule, but moreover, none of the auto manufacturers contested either rule. In fact, they intervened on EPA's behalf. They had long ago cut a deal with the administration, and they had accepted the consequences of those rules and were not challenging them. So you didn't have the parties directly regulated by either rule in front of the court, at least as a petitioner. And in fact, even some of the industry petitioners were very clear that they were not challenging the EPA rule as it applied to light-duty vehicles itself. So you wonder, why is this here at all? Why the challenge? Well, the challenge is really to try to address the shell game aspect of the rulemakings here, and that's one of the themes that the industry advocate, Peter Glazer, hit in his argument before the court. As you know, because Gabe mentioned it at the beginning, the tailpipe rule is the rule that EPA says triggered automatically the stationary source consequences under the Clean Air Act, under the PSD and Title V programs. If industry had not challenged that rule, then the Department of Justice and perhaps even the court may well have said, you have great arguments under the tailoring rule, but you really should have brought those under the tailpipe rule, because that's the rule that in fact triggered all these consequences in the first place. So in order to be sure that all of the industry arguments could be fully heard in at least one of the cases, there was a necessity to challenge the tailpipe rule as well. In a sense, there's really no choice but to do it. I'm only going to mention briefly what the chief arguments were, so it gives you a little bit of context when we talk about what Mr. Glazer and what the government intervener lawyers argued in the actual session before the court. There were just a few chief arguments at issue in the case. The first, admittedly a tough one, was that EPA did not have to regulate mobile sources, even having made the endangerment finding. In a sense, it was arguing that the word shall doesn't mean shall. under 202A of the Clean Air Act. Second, that EPA was compelled to avoid the absurd consequences that would flow to stationary sources by triggering under the tailpipe rule. Now that argument, variant of which was heard in the endangerment proceeding, looked at the absurdity doctrine in terms of how it applied to the dominoes that were at play here. You have endangerment, that tips over and triggers tailpipe, that tips over and triggers timing and tailoring. And the idea is that the government really ought to go back to the first domino, or if not the first, since it didn't look like that argument was gaining a lot of traction in the endangerment setting, the second domino, and apply it there and say, if this action is going to cause absurd consequences for the next domino, then you have an obligation to take that into consideration earlier rather than later. Then another major part of the arguments in the briefs, but also a central focus of Mr. Glazer's presentation, was that EPA failed to consider the stationary source consequences. In other words, to actually analyze the economic and other burdens that would be caused by issuing a tailpipe rule that would then trigger PSD and Title V applicability. Finally, industry argued that EPA should have seriously considered deferring regulation, and that the tailpipe rule did not rationally relate to the endangerment that was found in the endangerment rule. In other words, that it didn't really abate in any meaningful way the endangerment that EPA had found, and therefore it shouldn't have been promulgated. As Gabe also mentioned, it got the least amount of hearing time before the court, 20 minutes per side versus 45 for endangerment and 75 minutes for the tailoring and historic rules cases. For those of you who have some experience with the DC Circuit, you know that the kind of ordinary DC Circuit case usually gets 10 minutes of argument, maybe 15 per side. So it was really quite extraordinary that the court set aside 2 days for argument here and gave the parties as much time as it did. But the fact that the tailpipe rule got the least amount of time is harkens back to my opening line that this was somewhat of the odd man out of all of the other cases. In terms of the argument itself, out of what I just mentioned, Mr. Glazer focused really, at least primarily and initially, on the argument that the rule itself was unlawful because EPA did not investigate the consequences of that rule, and also that it did not rationally relate to the endangerment. But he didn't get very many words in before the questions started flying. And in fact, I would venture to say that the panel used most of its fire on petitioner's counsel and had a lot fewer questions for government counsel and the intervener counsel. Just to give you a flavor of what some of those inquiries were, a lot of the questioning came from Judge Tatel, as it did in all of the arguments, although Judge Sentel is certainly not shy in the least. As it pertains to statutory interpretation, notwithstanding Mr. Glazer's best efforts to steer the argument in the direction he wanted to go, Tatel very quickly turned it into an argument about statutory construction and what was permissible for EPA to do under Section 202A of the Act, having found endangerment. And in fact, with respect to the argument about stationary source impacts, Tatel asked the following question: wouldn't the Supreme Court have reversed if EPA had used stationary source impacts as an excuse not to regulate? Harkening back to Mass versus EPA. A tough question. He also focused very heavily on what is it in Section 202A, what explicit language is there in the statute that would give EPA the authority to look at impacts such as stationary source impacts when deciding what to do, if anything, about the mobile source emissions of greenhouse gases. Judge Sentel then rapidly followed up on that line of questions and asked, didn't Massachusetts say that EPA had to regulate if it found an endangerment? That's another tough question. Is there a mandatory obligation to go forward and issue those tailpipe standards once you found an endangerment? In fact, The endangerment findings historically have usually been wrapped together in a single rulemaking with whatever tailpipe or other mobile source emission standards have been promulgated by the agency. And a lot of the argument focused on mass versus EPA, and in fact, as we got to the absurdity argument, it became clear that Judge Tatel thought that industry was really arguing that it was the Supreme Court's decision in mass versus EPA that was absurd, not the statutory language itself. That was not a question to which the industry council responded directly. I think it just stood as an observation all by itself. Judge Tatel's perspective seemed to be that Section 202A2 is where EPA is given some flexibility in deciding how to address the actual standards to be promulgated themselves. But 202A1, at least it appeared from his questions, he thought essentially amounted to a mandatory obligation to issue regulations of some variety. After a tough 20 minutes of questioning, Mr. Glazer sat down and Eric Hostetler from the Department of Justice stood up. As I mentioned before, there were far fewer questions for him, but nonetheless, there were a few observations that the various judges made that led, I think, many who were watching the argument to believe that the panel was not foreclosing the possibility of some action on this challenge. Matter of fact, I think they were leaving as many options as possible open for themselves after the argument. There were a couple of statements you'll hear today, I'm sure, and you heard one from Tracy, that made it sound like there are a couple of issues that judges have largely come to grips with, but there are others with which they have not totally come to grips with. Judge Santel asked a very interesting question, and it really helps to understand why a lot of what we've been talking about today and is going to end up focusing on the second day of arguments that we'll hear about in a minute. He asked whether the absurd results doctrine, if available at all, expressing a little bit of skepticism about that, must be applied in the narrowest way possible. It was just a very general question, and the government advocates conceded that the answer was yes to that question. And I think that goes back to the dominoes that I mentioned earlier. The distinction industry had been making in the brief was that you should look kind of temporally back in time to various places in the chain of rulemakings where the doctrine could be applied, whereas Judge Santel seemed to be focused more on where could it be applied in the most narrow way possible, which I think he suggested through his question would probably be in the context of the tailoring rule itself. Judge Tatel kind of ended his questioning with a couple of observations, but the one that was most interesting to me was that he did mention, and did, contrary to some of his earlier questionings, did mention that the last sentence of the Mass versus EPA decision does in fact suggest that there is some room for EPA to take policy considerations into account in setting standards under the motor vehicle provisions. In other words, while Mass didn't give EPA any flexibility to make policy considerations in determining whether greenhouse gases were an air pollutant, that perhaps it does have the ability to look to policy justifications for its rulemaking. And in fact, many of the arguments made by the petitioners, you might say, amount in some part to policy arguments, especially to look at the stationary source consequences, the economic and other consequences of that rulemaking. So at the end of the day, I think that this challenge served the purpose that industry set out to obtain here. It was necessary to bring the judges through their questioning, at least made it seem like their interests on the stationary side of the arguments were going to lay primarily in the tailoring rule and in the historic rule challenges, not so much in the tailpipe rule, but they did leave open that possibility, and I think they do understand that there is somewhat of a shell game aspect to what's going on, whether you take that in a pejorative sense or just in a factual sense, that there are multiple rules and it's difficult for everyone to understand exactly in which rule the court is going to want to hear which argument. I will mention that just to echo what Tracy said a few minutes ago, the 4 versus 6 gases issue did come up also in the context of this rule. It came up in every single one of the oral arguments. It certainly was something that was not sitting right with Judge Santel. Whether that means he'll ultimately say anything about it in his opinion or not is very hard to predict, but it clearly was bothering him somewhat. And John, that's really all.
Tim, thank you very much. Meleah, if this case isn't complicated enough already, how do we inject a 30-year-old PSD rule into this equation?
Thanks, John. I wanted to thank ELI as well for the opportunity to speak here today. It's especially meaningful to me because these cases have kind of been my life for the past year and a half. So trying to now pull back and think about them in the big picture after the arguments is very interesting. I'll also say that I volunteered to cover this case in particular because it was not joined by the full panoply of various petitioners and interveners that we see in the other 3 cases. And I happen to have been one of the group involved in briefing the case as one of the groups that happened to be in this case. And now I'm sort of looking at the process of unpacking some of the discussion on the day and wondering whether I should have gone for something like endangerment or vehicles instead. For those of you who are very interested in questions of administrative law, I think the after arising grounds case, as it's become known as, or the historic regulations case, is probably one of the most interesting in terms of issues of finality and of ripeness and how they interplay with merits. As has been described, this is a case that was brought to some degree as a protective case because the real root of EPA's interpretation that led to regulation of greenhouse gases happened back in 1978 with its initial position about what subject to regulation means and when a pollutant is triggered, when a pollutant can trigger applicability of the PSD program. And that interpretation was not only articulated about 30 years ago, it also was reiterated in 2 subsequent rulemakings in 1980 and 2002, and yet to this day had not yet been litigated, or maybe it had been, which is one of the interesting questions here as well. So the petitioners, the small group of petitioners who brought this particular case had to get past the Clean Air Act's 307B1 60-day window for filing challenges to regulations. And there's, as some of you know, there's a provision that follows the 60-day window that says you can bring a case if it's based solely on grounds that arise after that window closes. So now we're looking at grounds that arise 6,000 days after the window closed, and the question is, can the petitioners now go after the root of the problem? The petitioners had alleged 3 general bases for the court's jurisdiction over this case. They'd claimed that the new regulation of greenhouse gases introduced unexpected difficulties that could not have been predicted during the original period for the challenge. They also claimed that the petitioners' claims only ripened when the vehicle rule resulted in greenhouse gas PSD actually applying to their members. In other words, that their injury only arose when EPA actually regulated the pollutant and not when it initially promulgated this interpretation. And they also argued that EPA had reopened this interpretation in the tailoring rule itself. EPA provided a few responses on each of these claims. Primarily, EPA argued that these claims are purely legal claims, that nothing about the statute has changed, nothing about how the mechanisms in the regulatory scheme has changed, this is all something that could have been raised back in the original rulemakings, and to some extent, or to a full extent, actually had been raised. The EPA also argued that the vehicle rule is not new grounds for these same reasons, and that it's only a changed factual factor so that the bases didn't fully arise or solely arise after the closed 60-day window. And they made some claims about the ripeness issue too, saying that ripeness is not a separate grounds, it's actually part of the grounds arising after doctrine in general, and that several cases that the court had heard previously lay out the concept that where a claim is purely legal, that cases challenging it are ripe when the regulations are promulgated. And EPA made another argument, an exhaustion argument, that if the court for any reason found that it had reopened its interpretation, or if there was ambiguity in the statute, that EPA should be given a chance to explain its interpretation in response to petitioner's petition for reconsideration, which was still pending before the agency. And so the judges are faced with this very strange posture where you have what was a very well understood regulation and how it operated for the past 30 years. It's an interpretation that states had relied on. It's an interpretation that industry as a whole was fully aware of. And yet you have these industry petitioners saying, we never had an interest in arguing about this interpretation before because we were never injured by it. There was no petitioner here who had this kind of impacts and kind of injuries that we're now seeing under greenhouse gas regulation until now. And of course, Judge Sentell started out by jumping all over the timeliness questions. The industry petitioners initially responded by saying that the question of whether EPA's reading is reasonable is not independent of what EPA did in the timing and tailoring rule, so this is obviously new grounds, and that because EPA had applied doctrines of last necessity in those rulemakings, EPA had to revisit its entire interpretation dating back to the older regulations. Judge Rogers, on the other hand, took the position of skeptic as to whether these are actually grounds arising after. She pointed out that petitioners had raised all of these issues before regarding other pollutants and had raised the same concerns with the economic consequences of the interpretation, namely that additional sources would be brought into the program and that the economic burdens of having done that would be too onerous on industry. And to that line of questioning, the petitioners responded that, in fact, the claims hadn't been raised in Alabama Power because at that time, again, none of them had been hurt by the rule. And I'll return a little bit to this question of what Alabama Power did or did not say in a minute. One of the arguments that petitioners had raised that the court really didn't want to hear about and kind of dismissed out of hand was this reopener theory. Judge Rogers started off by just simply cutting off the arguing attorney when he went to address that claim and said, I don't think that gets you where you want to go. And that was pretty much the end of reopener. It had come up once subsequently, and Judge Sentell turned to Judge Rogers and said, I think we don't want to hear about that. So that theory for why the court could have jurisdiction sounds like it's pretty much a no game there. The rightness issue was really, I think, where a fair number of interesting questions were raised, and I think both Judges Sentell and Tatel struggled with this idea that EPA was essentially saying that a regulated party would be forever barred from challenging a regulation, even though it would have lacked standing in the constitutional sense, and that its claims were not prudentially right, potentially, when that regulation was initially promulgated. And again, those two were the hardest on EPA in terms of their lines of questioning. In terms of the exhaustion issue, Judge Sentell was pursuing a line of questioning about why is EPA not arguing Chevron 2 here? Why is it only a Chevron 1 case as respects to the historic regulations? And he kept pressing on that repeatedly, but not really explaining his entire thinking on why that was an important factor. What DOJ responded in terms of the exhaustion argument was that it had not articulated a Chevron 2 basis in issuing those initial regulations. And for that reason, even though arguably it had articulated such a basis in timing and tailoring later on down the road, it should still be given a chance to go back and articulate that position for the purposes of the historic regulations. And in the lines of questioning, we again saw Judge Santel in particular was bothered by this idea. He was asking, well, what would we do on remand? What's the remedy for this? You would be going back and deciding this question when you've already cited a Chevron 2 basis in the subsequent rule. Judge Rogers picked up a little bit on this, saying that she doesn't think that this is an old J2 case, that basically there's a record showing whether or not this was reasonable and that we can decide that issue now. Turning a little bit to the merits and how it interplayed with the jurisdictional questions, as I mentioned earlier, this issue of what Alabama Power actually decided on the triggering mechanism was a significant area of interest for the court. In Alabama Power, there were passages explaining the interrelationship between sections 165 and 169 of the Clean Air Act, which are the two key provisions that EPA is relying on for its triggering interpretation, saying that these two provisions together, working together, 169 with the very broad definition of air pollutant as any air pollutant that is emitted above certain thresholds, and 165, which applies, again, to, as under EPA's interpretation, to require permits in any PSD area, meaning an area designated as attainment for any air pollutant. The Alabama Power case does indeed include a fair amount of discussion about the interaction between these two provisions, and opines that, directly opines that a pollutant that is not a NAAQS pollutant can in fact be a trigger for PSD. The industry petitioners claim that that portion of Alabama Power is dicta, that the court is not bound by that interpretation, and there was a fair amount of back and forth with EPA saying no, in fact, this was a core aspect of how the court interpreted those provisions. It was opining directly on this concept of applicability and which pollutants can trigger the program. And so, in fact, the court had already decided this question. Judge Tatel, in particular, seemed very interested in the question of whether Alabama Power had decided the issue at hand. He kept saying, if Alabama Power did decide this, then it's over. I think that one of the interesting questions will be whether Alabama Power can be read to have interpreted it in a way that would preclude the arguments about special circumstances that the petitioners raised. And so part of the interaction of the merits with the jurisdictional question is if that argument was actually litigated in Alabama Power, then to some extent it goes to this question of whether petitioners' claims were right back during the initial litigation over those historic regulations. I think I'll end it there and pass it off to the timing and tailoring role.
Good morning, everybody. I would like to also thank BLI for having me here today and calling me an expert on environmental matters. I know people like Tim and Allison, who's on the panel, cringe every time they hear me referred to as an expert, because I was really a newbie 3 years ago when these cases started. But having been lead counsel in 10 different cases styled Texas versus EPA, I have learned a thing or two about environmental law, and now that I'm back in private practice, I kind of like being called an environmental expert because calling myself a federalism expert doesn't seem to attract a lot of paying business. So that said, there's been a lot of in-depth discussion, nuanced discussion of the arguments, and unfortunately you're not going to get that from me. I see myself looking longingly at the bottom of the cup of coffee, kind of like a lot of you out there, so I'll try to be fairly short and leave time for questions, which obviously you all know a lot about these cases and probably have a lot of questions, but I do have some observations, and again, mine are probably from a more 50,000 foot view, but that perspective may be somewhat helpful. You know, when I first looked at these cases or the EPA action, my reaction was ignorant to say the least, but you know, ironically, several years later, a lot of the questions I had when I read the endangerment finding or the tailoring rule were kind of the same questions that the bench had. And some of the big issues that we all kind of noticed on day one were really kind of the same big issues that we were still grappling with yesterday and the day before. You know, we've heard a lot about the shell game or three-rule Monty or whatever you want to refer to it as. But I think, you know, one good thing about grouping the arguments was that it was, I think, easier for the court to see what EPA had attempted to do by promulgating its greenhouse gas regulatory regime over the course of 4 separate rules. I thought consolidating all those actions would have perhaps been better and eliminated a lot of the standing issues that the party spent a lot of time grappling with, which I think were just a byproduct of the separate rules. But nevertheless, hearing it over 2 days, I think was beneficial, and obviously they gave a lot of time. I will say I was terribly, terribly impressed with Judge Sentel's preparation. I've seen a lot of these arguments, not in the DC circuit, quite honestly, but a lot of appellate arguments in many different courts, and his depth of knowledge on this topic was impressive to say the least. And you know, it was one of those arguments where I was glad I wasn't making it because it was obvious the judge knew more about the case than I did. So what were the big issues in the tailoring rule? Well, the primary issue was obviously the conundrum that the tailoring rule provides relief. If the tailpipe rule triggers regulation, or the timing rule requires that regulation to be projected on to stationary sources, the object of the tailoring rule was to eliminate the number of sources which would be regulated. And I think in the introduction earlier, there was a reference to raising that threshold from 100 or 250 tons to 75,000 tons. Well, that's not actually correct. The EPA just didn't change the numbers, didn't just scratch them out and rewrite the numbers. They changed the method of how it was measured. The EPA does not measure tons anymore. They measure CO2 equivalents, which again, not just changing a numerical number, but also changing what was measured. It was like before the Clean Air Act measured height, and now it measures weight. I mean, perhaps not the best analogy, but I wasn't arguing. So it was a very pointed and significant, I would argue, obviously, and not everyone else would, rewriting of the statute. And that was the way Jonathan Mitchell, Texas's Solicitor General, kind of approached this case, which was stepping back from the environmental aspects of it. This was really a separation of powers case. This was a constitutional violation. And that's kind of the perspective that I've looked at these cases from for a few years. And, the court obviously had not. The court was, I don't want to say hostile to the position, but didn't take a shine to it immediately. I think the question was, well, administrative agencies take statutes all the time and interpret them, and petitioners challenge that interpretation, and how is this any different? And I haven't seen the thousands of petitions for review that the judges on the panel have, and perhaps that all of you have. To me, this did look different. To Jonathan, this did look different. To Texas, it looked different because it wasn't interpreting a phrase that said,
the house on Peach Street, but there's 2 Peach Streets in the town. It was 100 or 250 tons per year, which got interpreted to 75,000 CO2 equivalents. And the argument that Texas made, and that I was happy to see industry dovetail their arguments with and reinforce, was that this redrafting of the statute wasn't an interpretation, and in fact, it violated the constitutional separation of powers, which we all recall from high school or poli-sci degrees, which we parlayed into JDs, was that we have 3 separate branches of government, and Congress writes the laws and the executive branch interprets them. And the Texas view that the court did not, again, take so much of a shine to was that this was a complete redrafting. So a ton of time wasn't spent on that, but I was glad that the point was made, and ultimately the court, I think, will have to consider that whether they really want to or not. There was a lot of time spent on standing, and I think some of the laugh lines that apparently were in the papers, which I haven't read, were at the expense of Jonathan Mitchell, again, Texas's Solicitor General, who endured them greatly. But the argument that the parties have to make vis-a-vis the tailoring rule is, yes, knowing how the dominoes fall, okay, we now appreciate we are in a land of GHG regulation, and we are challenging an EPA rule that eliminates a significant portion of that burden, at least EPA argued. And we're looking to challenge that and have the burden increased. And of course the judges asked, a very basic question, which again we grappled with from day one, which was, if it's going to get worse, how does striking this order down provide you relief? Now everyone here knows the answer, and I think the answer was contained in the EPA's writing itself, which is, hey, if we have to regulate every stationary source that emits more than 100 or 250 tons of CO2 every year, we're going to bring 6 million different additional facilities into the regulatory regime. We can't do that. That creates absurd results. And in order to avoid those absurd results, we will employ the doctrine of administrative necessity and interpret 100 and 250 to mean 75,000 CO2 equivalent. The line I think that Judge Sentel had in response to the argument that, well, if we strike this rule down, EPA will be forced with deciding whether to pursue the absurd regulation or forego regulation entirely, was that doesn't even make good nonsense, which again, as counsel, as the oral advocate, you have to grin and bear, but it's a difficult position to be in because what you're really asking the court to do is to say, well, we have to hold EPA at its word, and EPA said that it couldn't and it wouldn't regulate all 6 million sources, so in fact this will provide us with relief. But that was a burden or a hill of persuasion that I hope was overcome, but it's again difficult to tell. And I will kind of say this is, I was trained as a trial lawyer and guessed what juries would do for dozens of years and never really got that right either. So I won't guess what these judges are going to do because they're people too and unpredictable. But as a general proposition, I think most people on the panel will agree that day 1 went better for EPA, day 2 went better for the petitioners, and it seems like that if there's a chink in EPA's armor, it is this tailoring rule. I think the bulk of the argument vis-a-vis EPA and after the jurisdictional issues were out of the way was the question of, well, the petitioners have provided 3 plausible alternative interpretations of the act that would not lead to absurd results. And EPA was asked pointedly and repeatedly whether that prevented them from resorting to the absurd results and administrative necessity doctrine. Why do you resort, or why do you turn to a doctrine of last resort when there are alternative reasonable interpretations that would allow you to avoid turning to that? And I think one thing that most people recognize is that EPA was unwilling to concede on that point, which of course no one would have expected them to. There was a decent amount of time that the judges and EPA's counsel took wrestling over that issue, with EPA refusing to concede that the mere existence of alternative reasonable explanations precluded EPA from employing administrative necessity and other doctrines of last resort. And I think there was just an agreement to disagree, obviously, but the court seemed, I don't want to say unanimously and solidly, but my gut would say that that's where they draw the line and say we're generally not hostile, but not loving of these doctrines of last resort, and if we can interpret the statute, and if the agency can interpret the statute in a way that allows them not to resort to them, then that's the interpretation we will require. Comments on the other rules, and again, I know I promised to not talk for a long time, and every time I make that promise, I break it. But my comments on the other few rules were kind of, again, from this 50,000-foot level of, endangerment. We all know of Mass versus EPA, and we all knew that these judges were the judges who decided it at the Intermediate Appellate Court, and that it would have an impact. It had a much bigger impact than I anticipated, and perhaps that's just my perspective. But I think the court really looked at Mass versus EPA and thought that it had decided a lot of issues in this case that, quite honestly, I thought remained open, and I didn't think Mass versus EPA covered explicitly. So that, I think will strongly influence where they go on this. Is just kind of that realpolitik view of, we've addressed these issues before, and from the court's perspective, we lost on these issues before, so now we know our marching orders and we know what to do. And again, I've never been an Intermediate Appellate Court judge, nor do I want to be, but they seem to feel that they're constrained in certain respects that I didn't think they would. From day one, as the non-environmental lawyer in the room talking about these cases, the thing that jumped out at me was the fact that the EPA was regulating two gases that weren't emitted from cars in a car rule. That struck me as, well, how can you do that, really? And I think the court had the exact same reaction. Now, I don't think it will ultimately end up mattering because no one would be swept into the GHG rules, at least based upon my understanding, solely by emitting those two gases. But it was an issue, I think, that drew attention to the fact, at least from my perspective, that EPA may be playing a little loose with the rules and with its regulatory authority. In closing, I'll just say I thought there were a lot of different problems, of course, with EPA's approach in all the various rules, and obviously, even when you're given that amount of time for oral argument by the court, you can't address them all. But the whole cumulative nature of the 20 different various and sundry attacks that petitioners could have made, I don't think it came across as well as I guess I would have hoped. I think as a general proposition, courts only obviously have time to address 2 or 3 issues in depth. Advocates only have time to address those, especially with a very hot bench. But the whole flavor, I wasn't sure came across to the court. I will say, perhaps unnecessarily, I thought all the advocates were excellent. Obviously, this was not a case where we had people who were ill-prepared or not up to the job. But I will also say I thought dividing the time amongst 3 or 4 advocates was ineffective. I think it's always ineffective. And I can say that because I wasn't amongst those people fighting for time. And I'm sure I'm offending someone, but that's kind of fun too. Generally, there was at least 2 or 3 questions every day from the judges, where the judges had a question about X, and the advocate had to say, X will be addressed by attorney Y. And that doesn't make for good oral argument and doesn't make for a good flow. And at the end of the day, you put up your best talker and, you let him or her run with it. That wasn't done here, and I understand that every client wants their own lawyer, and everyone's apparently an expert on a different issue. But, if I did have a criticism for the way that argument was handled, it was that division. Do I have a better solution that would make everyone happy? Of course not, but I don't have to. I'm speaking on a panel. So with that, again, I kind of would, I guess, be more comfortable responding to questions rather than just droning on and on. So I will stop the drone. I noticed a lot of you have already gotten up to get coffee before questions, or maybe just because I was boring and not entertaining, but we know someone who is, and that's John Cruden, so I'll turn it back to him.
Thank you, Bill. I am going to have a few questions, and we'll turn it over to you. But I do want to echo something that Bill said, which I said, and that is, come on, we have a lot of experience up here at this panel. We all agree. That was wonderful oral advocacy by every single person that stood up. Don't lose sight of that, because how everybody's arguing their case as best they could, and they did a really good job against, again, a very hot bench. First question will be just a clarification, then I have a question for the panel. Tim, Bill just talked about the standing issues that were raised by the states. What about industry? What about industry standing issues?
Well, I noticed immediately in many of the trade press alerts that came out right after the argument had headings that said that the court was challenging industry standing. But in fact, the standing questions all were directed, or primarily directed towards counsel for the state of Texas. And I think the court really was focused heavily on whether the state petitioners had standing to raise the arguments they wanted to pursue, which fundamentally related to the use of the absurdity doctrine and the rewriting of the statute and the tailoring rule. And in fact, there were very few standing questions directed to Mr. Brownell and virtually none directed to Mr. Kaiser. So I think that from the court's perspective, they weren't really focusing on standing versus industry.
Thank you. One question for the entire panel, but Tracy, I'll start with you. Tracy, this is an audience of administrative law wonks. They go to bed every night thinking about standing and thinking about canons of interpretation. And they were all waiting with bated breath to hear the absurdity doctrine debated and argued and trying to figure out where the limits were. And you mentioned that it got some play the first day, but I didn't hear much the second. What was happening?
I think there's a level of discomfort to some extent all around on that doctrine. And I think particularly because there are other doctrine available here, it seems certainly Judge Santel from day one, I think there was some point where he said, I don't do absurdity, I'll think about the other two maybe. When you hear that on the first day, maybe you talk more about the other doctrine at issue. I would. Others want to comment on the question and application and how the court played absurdity doctrine issues.
I'll jump in on this one because I think one of the interesting discussions in timing and tailoring was this question of whether we're in Chevron 1, and if we're not, and we're in Chevron 2, can the agency rely on one of the exemption doctrines as a basis for a demonstration that its interpretation is reasonable? And I think, there's a whole lot of question about how Chevron interplays with these doctrines and which realm we're in when we're looking at this decision. EPA put forth a very strong case that we're in Chevron 1, that the statute is very clear about the fact that greenhouse gases are part of the PSD statutory scheme, that the triggering mechanism works this way, and really that the only thing we have to deal with are these thresholds. I think, again, industry pushed back with an alternative interpretation of other parts of the statute that it claimed set out a clear path for how this is supposed to all work that would avoid having to deal with the thresholds entirely. And so whether the court will resolve that as a Chevron 1 issue, I think, is extraordinarily important. But as I said, the agency also advanced a Chevron 2 basis, saying, essentially, if we're not Chevron 1, for all of these same reasons, this is reasonable. And there was a very heated line of discussion at the end of part of the merits discussion and timing and tailoring of whether that's consistent. How can you say that something that produces, where you have discretion, something that produces absurd results is reasonable. And this was the question of whether EPA has an obligation to consider alternative interpretations that would avoid that absurdity completely. I think at one point, some of the trade press referred to that as something like, does EPA have to take the simplest route? And I don't think it really means that. I think EPA has the discretion under these doctrines to only depart as little as possible from the clear statutory meaning. But again, I think there's going to be the judges are really struggling with how to knit these various doctrines together. And because they're doctrines that have not gotten a lot of use in the past, exactly how that works has not been fully vetted. And I think we'll probably see a fairly lengthy discussion of that in the opinion. I think that's where I'll leave it on.
John, if I could add one
Please,
thing
go ahead.
there, which is I think that the absurdity doctrine did in fact play a very prominent and important role in day 2 in the following sense. And really, in a sense, it was running silent, but it was there. And it was there in the form of a question that Judge Tatel posed to Government Counsel Perry Rosen, not once, but at least 3 times. And to his credit, and I'm sure he has extra gold stars on his report card, he did not concede this point, even after 3 times in a row being asked the same hypothetical. But the hypothetical was, if you have a statute that is ambiguous and you have 2 plausible interpretations, both of which are reasonable and would pass Chevron 2 analysis, but one leads to absurd results, isn't the court compelled to the other one? Isn't the agency compelled to the other one? And in fact, that is the way in which absurdity really manifested itself in the second day of argument. Now, I would say that amusingly, at the end of that, just to give an anecdote, Judge Tatel, after the 3rd time, finally said, Mr. Rosen, it's clear that you don't want to answer my question, and I will politely stop and not ask you that question again. And within about 1 microsecond after Tatel shut his mouth, Judge Santel raised his already fairly loud voice about 10 decibels even higher and asked precisely the same question, word for word, that Judge Tatel had just said that he wouldn't pursue any further. But in any event, I think absurdity is nonetheless important because it's the pressure point that's pushing the court towards the other theories. And one other quick observation, which is Mr. Cobb mentioned that there are 3 alternative theories, and in fact there are 3 alternative theories that were in the briefs that were argued, although the 3rd wasn't really given much airtime. But I think when Judge Tatel was asking that hypothetical, he was really focused on 2 interpretations, one of which was the government's and the other of which would be the alternative. I think in context, it was fairly clear that the other one that he was talking about, at least then, was the theory that the PSD trigger should only apply to major emissions of a pollutant for which there is a national ambient air quality standard and for which the area of the country at issue is in attainment for that act.
And I would point out, and we'll see questions, that you always listen carefully for hints by judges in this context. Santel did ask at one stage, so do I really have to decide this, far out question dealing with absurd results, or can I just rely on one of the other 2 theories? And I think it was Eric Hostetler said, sure, you can rely on the others. Time for the audience. For those of you on the phone, we have about 160, 170 people here. For those of you who are present, we have about 150 people on the phone. Right this second. Questions of the audience, and if you have one, please identify who you are. Right there. Hey. Tracy, go ahead. One or more.
That's a good question. I think if you were if you were looking at the first day, it did seem, and I think, Tim, you mentioned this, that Judge Tatel and Judge Santel, or maybe you, John, were sort of finishing each other's sentences. So I think if you came out the first day, you might not be surprised to not see multiple opinions. I'm not sure that you would completely feel that way for the second day. There was a lot of different questioning, and I think the judges were fairly careful to leave things open, even sometimes sort of correcting things they had said to leave it a little bit more open. So I'm not sure on the second day. That's why I would think you'd be more likely to see more than one opinion.
I would just add that I noticed that the judges' law clerks, some of whom on the first day were on the left side sitting before laptops, and others of whom were sitting just observing from the jury box that's in the room, switched places on the second day, suggesting possibly that the court has kind of divided this into day one and day two for purposes of opinions, but that's pure speculation.
Yeah, I think because there are so many sub-issues, and because we did see a bit of a difference among some of the judges in a way that didn't seem resolved by the end of the arguments, I think you might see a couple of separate explanations of where those judges think they are. I think, again, the sixth pollutant issue in particular might be an interesting one. The example that was used over and over again by EPA on that issue was VOCs saying essentially we group pollutants all together for scientific purposes all the time. We don't require each of the regulated sources to emit every single one of them. This is this is extraordinarily normal practice. And Judge Rogers seemed very comfortable with that, and Judge Tatel didn't seem to have any questions, and it was really Judge Santel who was jumping all over this for purposes of the Section 202 analysis. Whether he decides that he's still not convinced is an interesting question, and whether he'll write separately just on that issue. But again, I think there are a lot of questions. I think for the most part the court will be able to come to a unified decision on some of the jurisdictional questions that I spoke about. I wouldn't be surprised again if you see them opining on some of the differences on the limits and how they interplay with some of the Chevron questions.
Yeah, when I heard the question, I guess my immediate thought was, do we get one opinion covering all 4 rules, or do we get separate opinions on each rule, which is kind of how I thought the question was intended, and it was kind of taken with whether we get a divided panel or not. I guess I would say I'm hopefully optimistic that there's one opinion that covers both days of arguments and all 4 or 5, however many rules you want to count it as. And I think the court probably out of prudence will try to find a way to all agree and all sign on to the same opinion. But again, perhaps that's more optimism and wishful thinking and practicality than nuanced analysis.
Since I took it a bit differently, I'll just comment on that as well. I think, from day one, the court has been not very open to the idea of treating these cases as one consolidated case. They denied some early procedural motions to basically squish all of them together. They've heard each one of them in separate sets of arguments, splitting up both endangerment and vehicles, and the only ones that they've really considered together, and which I think they might produce a single opinion for, are the after rising grounds and timing and tailoring, considering how interwoven all the issues there are. So I think at least if we can take the court's prior structuring of the cases in general and how it's chosen to have them briefed and how it's chosen to hear them, I think that we'll see that kind of a separation with separate opinions for the 2 day 1 cases and then a single opinion for the day 2 cases.
Oh, there's Tom Lorenzen.
Tom Lorenzen from the Department of Justice.
Stand up, Tom.
There was an interesting colloquy going on among the judges on the first day that I think were addressed to the oralists only once the question began to hurting. It was really more a debate among the judges. What is their proper role in judging the science questions? If there's competing evidence, do they just say EPA gets to decide, or do they have a deeper role as a court in that debate? I'm hearing the discussion.
I'm going to ask Bill to go first, but let me repeat it for those that are on the phone. The basic question is issues that were raised the first day by the court, asking what's the proper role of the court? What's the standard of review of the court when they're deciding some of these complex issues? Bill?
I was disappointed. I actually didn't see, not to say that there wasn't that internal discussion, but from my perspective, the court just basically said, any scientific determination, we're completely punting and just going to accept whatever EPA says. That's what I heard. I didn't really hear that the court was delving into whether it was proper for the EPA to rely on the wholesale outsourcing of its assessment to IPCC. I didn't really hear the court grappling with other issues that I thought would have, indicated that they were seriously considered not just deferring entirely to EPA. So, my gut would be that, endangerment stands, that the court just defers on the basis that this is a scientific determination by an expert administrative agency, because their questions really, I don't think, were drilling down into some of the significant issues, I thought, with the finding itself.
I would only point out that Tatel was a law professor in his life. He asked the question. There were lots of law students in the area, and it's a question that we have been debating for decades about what the role of the court is under these circumstances, both pre and post Chevron. So it's somewhat a delightful question, even though I don't disagree. But others, more questions, please. For the audience, the question is about the tailoring rule. Basically, what happens if EPA loses? Meleah, I'm going to direct that question at you. Do you have any thoughts?
Well, just going to the constitutional issue first, I don't think there's a very strong likelihood that the court will go there based on its questions. And I'm saying this again, not trying to project where they'll go, but based solely on the fact that they were very skeptical about the argument that there was an improper, that applying the non-delegation doctrine here is appropriate. I do think that the court will likely find a way, if it believes that the threshold issues are problematic, to just find that there is no greenhouse gas authority, that there is some sort of carve-out for the purposes of this program. One of the hypotheticals that was thrown out and that produced one of the laugh lines from Judge Tatel was this concept that we will, we'll just open the floodgates, EPA regulates down to the thresholds, and we'll wait for Congress to do something. And I think he said something like, any sentence that begins with Congress will is just a non-starter. So, it's hard to project what will happen there. I think the court will most likely understand the difficult situation that such a decision would produce. So, again, not wanting to state right now, given that we're all parties on the brief, what we think the answer, what the court's decision will lay out. I think it will find some way to thread a position where we will not see everything all of a sudden flooding in.
Other last comments by panelist members?
Yeah, I don't have as much discretion, I guess. And I think EPA went down this road from day one to inspire Congress to act. And, I think that was a point that petitioners tried to make. And I don't want to say it fell on deaf ears at the court, but they certainly weren't going to draft an opinion, again, based upon what they thought Congress was going to do. But I think, to answer the question, they could write an opinion that would force Congress to act, and maybe that's the best way to do it, is to hold EPA's feet to the fire and to the statute and say, okay, go ahead and regulate greenhouse gases emitted from every facility pursuant to the terms of the statute. And if you can do it, great, and if you can't, don't. And if the people want to do something else, that's why they have the legislative branch of government. So I could see it going that way, but, again, perhaps for the reasons Meleah pointed out.
Well, the last 2 days were extraordinary in the ceremonial courtroom of D.C., but it's actually quite extraordinary to have 4 experts, and yes, Bill, that includes you, who participated in the briefing, who were there to be able to take time and explain to you what they thought they heard. I'd like to have a round of applause for these four panelists.